Ivan Atsaside was imprisoned in Luzira for 6 years, following a case in which he was accused by his employers of causing the company financial loss. Atsaside's story is an example of some of the consequences of a slow and overburdened judiciary system in which cases are not quickly disposed of due to structural problems and systemic failures.
He was available, but it reached at the time in July, August, when he had, I think, the holidays. They said the holidays, so they adjourned our file for almost 2 months.
At Atsaside's arrest, the long period it took to process his case and the eventual conviction wrecked his life.
Of course, the time we were put in prison, the money we had in our pockets, and some developments, see some projects, they all went. So you find when you have nothing like now. No wife, only I had someone whom I used to see and I prepared to marry her, but by the time I was put in prison, she went away.
Atsaside is convinced that if the judicial system had fewer cases to handle, his case wouldn't have taken as long and his life would be different.
That one is caused by the problem of lacking the judges. As you hear that in our country, Uganda, we have less than 53 judges. They say there are 51, 52 there, so I think if they can also add on the judges, then justice there may be may be given to people, even the poor one.
In March 2018, Parliament passed a resolution to increase the number of High Court judges from 49 to 82 after it was found that the number was too small to tackle the ever-rising case backlog. This came on the heels of demands for more judges by different stakeholders. However, despite Parliament's resolution, the required numbers have not yet been met. Solomon Mwita, the judiciary spokesperson, says it would require at least 200 judges to get the current case backlog brought to manageable levels.
If we are to clear all those cases in 1 year, we require 200 judges, but we have 52.
Chief Justice Bat Katurebe has on several occasions decried the underfunding, the understaffing of the judiciary, adding that judicial officers are doing their best to handle the cases before them, but the filing of cases has tripled, stretching them beyond human capacity. Mwit explains why there is an increase in the number of cases before the different courts.
A report which was made by Hill, it shows that people who have come through the court system, 80% are happy with the court services. So those people who are happy with the court services go out there and spread the word, and they cause more people to come into the system.
According to Mwita, the judiciary is trying to deal with the case backlog in a number of ways.
Initiatives that have been designed to quicken access to justice. We started with plea bargaining in criminal matters, where we encourage people who know that they really committed the offenses. They shouldn't sit back and wait for witnesses to be brought and, arguing of the matter for a long time. We encourage them to plead guilty, and then you have an opportunity to negotiate for a lesser sentence.
However, the spokesperson of the Uganda Prison Service, Frank Baine, is critical of the plea bargaining approach.
The person must accept guilt. While plea bargaining works for those who are convinced offenders, there are those who say, please, can you attend to me? I am innocent. So in which case plea bargaining does not help the crying innocent, but it helps those who say, for us, we are ready to tell you we did it as long as we get a compromise.
Baine believes the local courts must be empowered to address the question of backlogs and prison overcrowding.
There are a number of things which we must do very, 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 very important. That we have to encourage as much as possible alternative to incarceration methods. We have to get back to our traditional justice systems.
As the situation stands right now, the judiciary needs 530 grade 1 magistrates, but there are only 192. 200 judges are needed, but only 52 are currently employed. According to a report by the Case Backlog Reduction Committee, more than 155,400 cases were pending at all levels of courts as of January 31st this year. The report shows that criminal cases constitute 44% of unresolved cases, civil cases are 33%, land cases are 14%, family cases are 3%, while commercial cases constitute 2%. In order to deal with the backlog problem, the judiciary has considered the following strategies. Strategy 1, deliver all overdue pending judgments. 2, clear all cases that are more than 2 years old after filing within 20 months. 3, develop and implement case backlog clearance plans for each court. 4, strengthen existing initiatives such as the plea bargaining, mediation and small claims etc. 5, develop and implement a judiciary-specific anti-corruption strategy. 6, increase the number of judicial officers and administrative staff at all levels of the courts. 7, review of procedures that cause delays and advocate for reforms of law. Strategy 8, review the business processes in the judiciary and computerize filing and storage of documents and introduce critical indicators that could be flagged once deadlines have been missed. Andrew Chamagero, NTV News.